Hello. This 10-minute video will provide an overview of the UK Government's commitment to ensure no diminution of certain rights, safeguards and equality protections as a result of Brexit. Following the UK's decision to leave the EU, many worked to ensure that human rights and equality would be protected after Brexit. The result is the no diminution commitment in Article 2 of the Windsor Framework, which is part of the UK-EU Withdrawal Agreement of 2020. The Windsor Framework was formerly titled the Protocol on Ireland, Northern Ireland, and any references in Commission materials to the Protocol should now be understood as references to the Windsor Framework. Article 2 is an acknowledgement of the role of the EU in advancing human rights and equality during the period of our membership, and the centrality of rights to the Belfast Good Friday Agreement and the peace process. It offers a degree of certainty and stability at a time of unanticipated change and in the context of continuing controversy about rights and equality in Northern Ireland. But its protection is limited. It is no substitute for a comprehensive human rights and equality framework.
Looking at the text itself for a moment, you will see it is a complex provision. The no diminution commitment is qualified in a number of ways before a particular area is highlighted. The first important point is that this is a commitment by the UK government rather than the EU, though of course both parties have to work together in good faith to implement the treaty. Then we have two important caveats. First, the rights or protections have to be covered by the relevant chapter of the Belfast Good Friday Agreement, and we'll return to this in a moment. Secondly, the commitment is to no diminution as a result of Brexit. This means we have to look at what was required when the UK was an EU member state. By and large, it refers to EU law binding on the UK as of the 31st of December 2020. But the second half of the text provides special protection in the area of discrimination. The 6 equality directives listed in Annex 1 are subject to a higher standard. Where the EU increases minimum levels of protection, the law in Northern Ireland will have to keep pace. The Commissions have been researching and developing our interpretation of Article 2, but this is a work of progress and will be shaped by future court decisions. To understand in more detail what Article 2 means, we need to first look at the relevant chapter of the Belfast Good Friday Agreement.
The Rights, Safeguards and Equality of Opportunity chapter of the Belfast Good Friday Agreement is broadly scoped and includes a non-exhaustive list of rights which are affirmed in particular. A range of other issues are covered. It doesn't include the right to identify and be accepted as Irish or British or both. This is found in a different section of the agreement. But note the wide commitment to the civil rights and religious liberties of everyone in the community. This section also sees the UK government commit to giving domestic effect to the European Convention on Human Rights. The government has acknowledged that many of the rights in the agreement are underpinned by the Convention. This chapter of the agreement also anticipates the development of a Bill of Rights for Northern Ireland, which would include rights supplementary to the ECHR and draw on international standards. In terms of using this chapter to understand the scope of Article 2, it is worth noting that the agreement was not drafted as a legal text or a complete statement of rights. It is a political document, loosely worded, with no definitions, no footnotes or interpretation clause. It is clear, however, that the signatories were making a broad commitment to human rights and equality. In their declaration of support, they state that the object and purpose of the agreement was to set the framework for peace, reconciliation and the enjoyment of human rights in Northern Ireland. This is consistent with the general commitment to the civil rights and religious liberties of everyone in the community. The Commissions are therefore reading this chapter as evidence of a wide-ranging commitment rather than precisely enumerated rights. Turning to what this means for identifying relevant EU legal standards, we take the view that as a minimum, all EU law is within scope of Article 2 to the extent that it underpins ECHR rights. One question is how to read the equality commitments in the agreement. These are formulated variously. There is reference to equality of opportunity, listing 5 grounds of protection against discrimination. A new public sector duty, listing 9 categories of protection. Reference to the European Convention on Human Rights, which offers protection on additional grounds. And under the withdrawal agreement, the Charter of Fundamental Rights of the EU remains relevant for interpretation of the treaty, including Article 2 of the Windsor Framework. Article 21 of that Charter sets out some 14 grounds of protection against discrimination. The Commissions therefore take the view that it is reasonable to take a broad reading of the signatories' commitment to equality of opportunity. Likewise, in view of the objectives set out in the Declaration of Support, the commitment to civil rights, and the range of rights addressed in the relevant chapter, we suggest it is arguable that the signatories' commitment to rights could be understood as encompassing wider international treaties ratified by the UK. Again, such treaties would only be relevant to Article 2 to the extent that their provisions are underpinned by EU law. Turning to what no diminution means. The law in Northern Ireland can be amended. It can use different words, it can be reframed to sit within our legal context, but the level of protection afforded to individuals is key. It is an obligation of result. Article 2 of the Windsor Framework doesn't sit on its own, but must be read in context. Notably, Article 13. Article 13.3 states that references to EU law in what was the protocol are to that law as amended or replaced. In other words, the standards applicable in Northern Ireland are determined by the current version of the legislation as it is gradually updated or replaced. This is what creates the keeping pace obligation in relation to the 6 named equality directives in Annex 1. Article 13.2 is also important. It distinguishes the Windsor Framework from the time-bound commitment to EU case law set out in the main agreement. Instead, it says that references in the Windsor Framework to EU law or EU legal concepts must be interpreted in line with CJEU case law on an ongoing basis.
The withdrawal agreement, including the Windsor Framework, is a binding international treaty. It has been incorporated or brought into UK domestic law by the EU Withdrawal Act and the EU Withdrawal Agreement Act, passed by the Westminster Parliament. The Northern Ireland Act 1998 has been changed to make clear that legislation can be overturned if it is not compliant with Article 2, and that ministers' decisions must likewise comply. Westminster legislation can also be challenged if it does not conform. Article 2 states that the commitment will be overseen by dedicated mechanisms, and this resulted in new statutory functions for the Northern Ireland Human Rights Commission and the Equality Commission for Northern Ireland. The commissions have legal powers to initiate, support or intervene in court cases with or without the involvement of a victim. The commissions can also raise issues with the UK-EU Specialised Committee on the Windsor Framework. But it is not only the commissions that can hold government to account. Individuals can go to court if they feel their rights have been diminished contrary to Article 2. Please get in touch with us if you feel this is the case. As a result of the Windsor Framework, the Human Rights Commission and the Equality Commission in Northern Ireland work with the Irish Human Rights and Equality Commission to report and advise on issues falling within Article 2 that have an Island of Ireland dimension. The next video will demonstrate how the Commission considers whether or not there has been a breach of Article 2 and work through an example.